When your child is hurt in an accident, parents often ask, what can I do legally? And let's go over what your legal obligations and responsibilities are when your child is hurt in an accident. In Florida, a parent can bring a claim on behalf of their minor child. In fact, they have to bring a claim on behalf of the minor child within 2 years of the accident, or that child will be forever barred for bringing a claim themselves once they reach 18. In Florida, the parent acting as the natural guardian can bring a claim on behalf of the child, or a legal guardian can bring a claim on behalf of a child who's under 18. What we want to do is our client will then be the child and the parents, and we'll be acting in the best interest of the child, as the parents are supposed to be acting in the best interest of the child, making sure that the child is getting the proper medical treatment, the medical care, and then we're going to be making sure that we're getting all of that child's medical bills paid for. We're going to be making sure that any type of scarring and disability caused by an accident is being paid for out of any settlement or verdict. And we're also making sure that the doctors are providing the proper opinions regarding the need for future medical treatment regarding the injuries they sustained in an accident. They'll also provide opinions regarding not only the need for future medical treatment, but how much that treatment will cost, what type of prognosis your child will have. Is the child going to be better within a few months, or is the child going to be left with permanent, chronic type of problems, pain and disability? We take all that into account to help determine the value of the case. There are specific rules in Florida regarding how we can settle your child's case. If the case is worth less than $15,000, the parent and natural guardian through the attorney can settle it without court intervention. And that money goes to the parents to be used for the benefit of the child. If the value of the settlement is greater than $15,000, we have to get court approval, and that is a much more complex set of rules that has to be followed in every single case. We want to make sure that your child is getting the proper medical treatment, that all the opinions necessary to properly evaluate the claim are obtained from doctors and other experts, and then that allows us to either settle the case without court approval up to $15,000, or if it is worth anything more than $15,000 and above, then we go ahead and seek court approval for that settlement. If you have any other questions regarding your child's injury and what you're entitled to and what your child is entitled to, please reach out to us. Call Hancock Injury Attorneys. I'll be happy to speak with you and answer any other questions you may have.